for the record for the state,
Kathleen Pollard for the state.
for the defense.
John Coons for Mr. Condell.
And are you Mr. Condell?
Yes, yes, ma'am.
All right, I'm gonna need you to make sure that you speak up so that we can hear you. Okay? Counsel, I'm showing you what's entitled Discovery Acknowledgement. Have you received all the discovery in this case and did you review it with your client?
I have, Your Honor. Yes, we did.
Court will find that the state is in compliance with discovery. Mr. Condell, I'm showing you what's entitled Deferred Adjudication Application. Did you review that with your attorney? Did you understand it and did you sign it? Next, I'm showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We do.
State, are you proceeding on the indictment as presented?
Judge, I believe we're proceeding in count one.
That's correct, Your Honor. We have no objection.
Mr. Condell, I'm showing you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with the offense of aggravated assault with a deadly weapon? That's a second-degree felony. The range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could sentence you up to 20 years in prison and up to $10,000 fine?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Judge.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He certainly does.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do, Your Honor.
Mr. Condell, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea bargain agreement?
No, ma'am.
Are you satisfied with the way you've been represented?
I am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page, did you review that with your attorney? Did you understand it?
Yes, ma'am.
According to the plea bargain agreement, the state is proceeding on count one. Punishment is to be assessed at 4 years in the prison. There's a $1,500 fine. The state is silent on your application for deferred adjudication. There's to be no contact with Tiffany McDonald or Marvell, Marvelle Martinez. And there's an affirmative finding of family violence. Did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition?
Yes.
Did you understand with an affirmative finding of family violence, you're not allowed to be designated as primary custodial parent?
Yes, ma'am.
Did you understand that to be the entirety of your plea bargain agreement? State,
Yes, Judge.
defense?
Yes, Judge.
See, I looked at you,
You
but
did. You're trying to-
it throws everybody off, right? Next, I'm showing you what's entitled Waiver of Appeal paragraph. Did you review that with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
No, Your Honor.
Then to the offenses charged in count one, how do you plead? Guilty, not guilty, or no contest? State any evidence.
Yes, Judge, we'd offer what's part of the state's exhibit one.
We reviewed them and have no objection.
Mr. Condell, I'm showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it at all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. After reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Are we proceeding with sentencing?
Yes, Judge, we'd request that.
All right. And the court will note for the record that the defendant was placed on supervision in 2019 CR 0950. A motion to revoke was heard in regards to that. Council, is that correct?
Several months ago it was, Your Honor, and then this new indictment popped up from an offense alleged to have occurred earlier this year prior to us resolving his MTR in the summer. So we're obviously requesting that you place him on deferred, run it concurrently with the case that he is currently on deferred for, with the same terms and conditions that you've already applied to that first case.
And in regards to the first case, it's the court's understanding, is the defendant scheduled for SATF?
DDRF, I believe.
DDRF, okay,
That's correct.
Yes.
all right. State, any objections?
No objections.
All right, so this is what the court will do in this case. As previously stated, the court is finding there's sufficient evidence to find you guilty. The court will defer finding of guilt, place you on deferred adjudication for a term of 4 years.
Judge, would it be possible to give him a lower term of years in terms of, I believe he only has about 2 years to go on his existing probation.
No, it will depend, if he wants to come back, if he's doing well, then the court, of course, may reconsider things.
Okay.
Okay, all right, so this, with regards to that, if you're doing well, if you're following all the rules and the regulations, then your attorney, of course, can come back later and ask that you be terminated early. And I will consider that. I always keep an open mind about everything. But for now, I'm going to have you on 4 years deferred adjudication. This is the run concurrent with 2019 CR 0950. There's a $1,500 fine that will be probated.
Thank you, Judge.
There's to be no contact with Tiffany McDonald, Marvell Martinez. There's an affirmative finding of family violence. There should be the DDRF. I'm going to have you on GPS when you're released from DDRF. Okay? Yes. So I'm going to want GPS upon release from DDRF. And we can do partial for work. There's to be parenting classes. Do you have a child? I'm reading the report that you do. Age?
One is 3 years old and one is about to turn 1.
All right. So we're going to do parenting classes. There's to be no unsupervised contact with minors. Proof of employment or SSI. Within 90 days of release from custody. There's to be regular reporting by Zoom or in person. And I saw at one point I asked that he go to SATF. Were there drug issues in this as well as mental health issues?
Judge, you're catching me on the wrong foot. I don't know.
Okay, I think there was.
He can address it.
Yes.
I originally ended up going to Lifetime because there was substance abuse, and while going through Lifetime, they dealt with mental health issues that I hadn't been diagnosed with yet. So once I completed that, the mental health diagnosis is being taken care of now. It was in the process.
Okay. So do you have a case manager and everything?
I do.
All right. So you're going to have to make sure that you give probation the name of your case manager.
Okay.
All right. I'm going to want field visits 2 times per month. And probation, if you can make sure they check in with his case manager to make sure that he's on his medications. And there'll be regular UAs. Probation, is there anything else he needs?
Your Honor.
Is there anything else you need from the court to be successful? I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it and did you sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
All right, State, are you withdrawing the motion to revoke or are you going forward on it?
Judge, we're withdrawing.
Okay,
Thank you. We have no objection.
all right. So, Mr. Condell, we're off the record. Mr. Condell, you're gonna have to make sure that you follow through on everything. So when you go to DDRF, when you're released from DDRF, you need to make sure that you stay in contact with your case manager, okay? All right, thank you. Just have a seat and probation. We'll go over conditions with you. The court is calling 2022 CR 0117, State of Texas versus Danny Ray Machado. Could I have parties announced for the record for the state?
Catherine Pollard for the state.
Mr. Machado.
All right, and are you Mr. Danny Machado?
Yes, ma'am.
All right, you entered a plea of no contest on September 29th to the offense of assault family second. According to the plea bargaining agreement, punishment is to be assessed at a cap of 5 years, and the state is remaining silent on your application. Have both parties had a chance to review the PSI report?
Yes, Judge.
We have none.
Any objections?
No, there were no objections.
All right, the state is silent. So, defense?
Judge, what I'd like you to know about Danny is that this particular offense goes back February, it'll be 2 years. Since that time, he and the complaining witness have not had any problems or any further incidents. He's 36 years old. He works with a company called Fuller Excavation. He's a survey engineer with that company, been so since May of 2021. And before that, he was a carpenter with Bartlett Cook. He has a child with the complaining witness, and he has 2 other children. He currently pays approximately $700 a month in child support and is current. He has a hearing coming up on December 13th for the 3rd time. He lives with his father. He was living with the complainant at this time on and off, but now when this happened, he moved out. He's living with his father and his stepmother since then. And things are going well over there. On the PSI, when you asked me one thing, I knew there was something. On the front page of the PSI, there's a reference to this is happening on 1/2/22. That date's not right. That was something else that was dismissed. The actual offense date in this one's 2/27/21. Yeah, it was on almost all the way at the bottom of page 1 when the wrong date was put in.
All right, is there anything else?
Yeah. Mr. Machado had a letter from his boss on a character kind of need to also verifying his employment. It was my understanding that that letter was supposed to be attached to the PSI report by Ms. Martinez, I believe it was, who did it. When I reviewed the PSI, it was not attached. However, we do have confirmation from her that she did receive it. And that's
Well,
on-
is this the letter that is from Fuller Concrete?
Yes.
Yes, I have it attached to
Oh,
mine.
okay, it was not in the copy that I saw. But I think. Yes, that's the letter. Yes.
All right.
Yes, ma'am, that is the letter.
And just so both parties know, I review the PSI reports always before sentencing, and I read everything that's in it. And then if there's something that people want me to disregard, I will immediately disregard it. But I did read the letter from his employer.
Thank you.
You're welcome.
Now, what I would draw your attention to, if the court, or we are asking the courts to defer adjudication, probation. I was looking at the TRAS, the TRAS evaluation that's on page 9
Mhm.
of the report. If granted probation, they're recommending that supervision be at the low region. Also that they did note that he is in a pre-contemplative stage of change, which indicated to me he's working on himself. outpatient treatment for alcohol. No contact order with the complaining witness, BIP, community service. All of those seem very reasonable and something that I think Mr. Machado could do and would do in order to successfully complete a probation. And that's what I have to say from Machado, and he would have to address the court as well.
All right, can you raise your right hand for me? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
You can lower your hand, state your name for the record.
Danny Machado.
All right, what would you like to say?
First off, I just want to say that I'm very sorry and remorseful about everything that happened. That is just not me, it's not in my character.
Wait, stop right there. You're saying that's not in your character?
Yeah, that's not me. That's not
Is this
me.
the first time that this has happened?
No, man, so
So it is maybe in your character.
it's, and I'm willing to do anything to better myself as far as classes. I feel that I've come a long way as far as change. And
Let me ask you this. Have you read her statement?
yes, man.
All right. I want you to read that out loud.
Everything.
Yeah, the first paragraph.
The officer spoke to the complainant.
No. Slow it down and speak up so I can hear you.
This officer spoke to the complainant who stated, I am in corrections in January.
You all need to be quiet over there, please.
I am
Yes.
in corrections. In January, it will be 15 years. Danny and I have been married for 7 years, and I have been abused throughout the marriage. He has put me in the hospital several times. I have been planning to leave him for 12 months after the incident, but he wouldn't leave me. He wouldn't let me leave. It took a lot for me to get to this point, but I'm glad I did. I'm in a good place where we have one minor child together and I have 3 other children outside this relationship. Even with no contact order, he still contacts me through the phone calls. Where you at? You're still mine. I'm outspoken. I'm forgiven. I've forgiven him, but I'll tell my story. He has a case that involved all our kids. He hit me with 6 kids in the vehicle. CPS got involved. He's done a couple of years probation and he's anger management, parenting therapy, the whole 9. And I clearly didn't work. The female he's with, he's doing the same thing and she called the cops, but he recants. Something like that.
But she recants. So do you have any response to that?
Yeah, as far as me being in a relationship, I'm no longer in a relationship. I mean, it's some of that's not really true.
Well, I mean, so here's the thing. You come to me and you say that hitting her is not in your character. But then I have evidence that you've done this before.
Yes, we had a rough relationship. I'm not gonna say it was perfect. But since the incident happened, we haven't been together. We've been apart. And since then, I feel like I've done a lot better. And the thing that I've been doing now, I've been going to church, been changed. As far as career wise, I've overcome a lot, and things I've been doing a lot better. And I've been trying to work my way up.
All right. Is there anything else you wish to say? Defense, any questions?
You have some plans for your future as far as what you want to do, even though you are a surveyor for Fuller. What are those plans?
Yes, ma'am. Right now, though, this is a setback because I'm trying to finish the enrollment for my school so I can start my own company and take off with that. But as far as that, that's postponed for now.
You had also indicated to me what you felt about counseling for yourself in several areas. Would you tell the judge about
So
that?
yes, I'm all for it in any classes that would help as far as making me a better person overall. I'm all for it.
Two of the specific areas that we concentrated on were alcohol, is that correct?
Yes, sir.
And anger management, is that correct?
Yes,
And any course that you would be
yes,
told to do, I assume you would do.
yes, yes, sir.
State any questions? All right. Any other witnesses?
No, ma'am.
All right.
I will say his mother is here for support.
Okay.
So she is here. He does have family support outside of this, and he does live with his father and stepmother who also are supported in that.
Okay. This is what the court is going to do. The court is going to find you guilty. The court will deny your applications. There's an affirmative finding of family violence. There's to be no contact with Brittany Machado. There's to be no unsupervised contact with minors. There's a $1,500 fine, time and money to run concurrent, taking consideration grand jury number 779534. Court will sentence you to 5 years in prison, give you credit for any time served. Showing you what's entitled trial court certification of defendant's rights to appeal. Did you review that with your attorney? Did you understand it and did you sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand? Because this